If the insurance company's offer feels insultingly low, you're not imagining it. Here's how injury cases are actually valued in Texas and what really controls what you receive. Hi, I'm attorney Greg Oberg. For over 30 years, my firm and I have been fighting for injured Texans, working to get every client the maximum compensation they deserve. If you or your loved one have been hurt in an accident, let's talk. Give us a call at 972-682-9700 for a free consultation. Here's the honest truth. There isn't a one-size formula that spits out a dollar amount. Value is built from evidence and law, then tested against the realities of insurance and juries. Think of it as a triangle with three sides: liability, damages, and ability to pay. If any side is weak, the number drops. If all three are solid, your negotiating power grows. With that framework in mind, we'll move piece by piece, beginning with the foundation. Liability answers one question: what did the other person or company do wrong, and can you prove it? In Texas, your recovery is reduced by your percentage of fault, and if you're more than 50% responsible, you recover nothing. That makes clean, objective proof priceless. Police reports, scene photos, dash or security video, black box data from vehicles, and witness statements gathered while memories are fresh all help anchor fault where it belongs. Sometimes liability is straightforward: rear-end impact at a light, a left turn across oncoming traffic, or a drunk driver swerving through lanes. Other times, it's more technical, like a premises case that turns on inspection logs and the store's notice of a hazard, or a trucking case where hours of service violations, skipped brake inspections, or overloading push fault toward the carrier. The stronger your proof, the easier it is to shut down blame shifting and the "you should have avoided it" argument. Be realistic about weak spots. If fault is disputed, you plan for it early. Preserve video before it's overwritten, get a formal preservation letter out for data and logs, and consider expert help when measurements or reconstructions will clarify what happened. Investing in liability proof doesn't just win trials, it raises settlement value today because adjusters price what a jury could see tomorrow. Once fault is pinned down, the next question is what the crash cost you on paper and in real life. Damages are the legally recognized losses tied to the incident. In Texas, juries consider both economic losses you can count and human losses you live with. Four categories tend to carry the most weight. The first category is pain and suffering. These are the human damages: physical pain, mental anguish, loss of enjoyment, anxiety that lingers in traffic, sleep disruption, and the frustration of being limited. Specifics persuade. Short daily notes, such as how long you can stand before your back locks up, the hobbies you've paused, or the way driving now triggers headaches, translate invisible harm into credible case-building detail. Medical records should echo these realities. When you tell your providers what daily life looks like, those notes become evidence, not just complaints. Next, lost wages. Lost wages can be simple when a doctor orders time off and your employer confirms dates and pay. They can also be complex. Maybe you returned but can't do overtime, lift, or travel. Maybe pain slows you enough that you miss opportunities. In larger cases, diminished earning capacity matters: what you're reasonably likely to lose in future income because you can't return to the same work. Get restrictions in writing. Ask your employer for a letter documenting missed time, modified duties, and lost opportunities so the math isn't guesswork. Third is physical scars. Scarring and disfigurement are visible reminders of a crash. Photograph healing at intervals and note tenderness, weather sensitivity, or functional limits. If a scar is on the face, neck, or hands, or if it affects your work or confidence, make sure your provider documents that impact. Juries respond to clear, respectful proof of how everyday interactions change when scars draw attention first. And fourth category, medical expenses. Texas uses a paid or incurred framework, which means the recoverable medicals usually reflect amounts paid or still owed after insurance adjustments, not the raw sticker price. Practically, you still gather every itemized bill and explanation of benefits because they show scope and necessity of care: ER, imaging, specialist visits, surgeries, injections, therapy, medications, and anticipated future treatment if your provider expects more care. Link each cost to a diagnosis and a date. That structure makes adjusters do math instead of arguing assumptions. Strong damages don't matter if there's no source to pay them. That's where the third side of the triangle comes in. Ability to pay usually means insurance, policy limits, and available coverages. If the at-fault driver carries state minimum limits and your losses exceed them, you may need to access your own underinsured motorist (UIM) coverage. In commercial or trucking cases, higher limits or self-insured entities change the landscape. In premises cases involving national retailers, corporate policies or excess layers may be in play. Investigate early. Verify the at-fault liability limits. Check your declarations page for UM/UIM and don't inadvertently sign releases that waive your rights to pursue additional coverage. Collecting outside of insurance from an individual is often unrealistic. From corporations, it may not be necessary because coverage is higher, but you still have to prove the claim. The bottom line, knowing the ceiling guides strategy, timing, and expectations. With the triangle built, real-world factors still influence value at the margins. Let's make those explicit. Credibility is a value multiplier. Consistent medical care, honest descriptions of pain, and records that match what you say on the phone, in forms, and online build trust. Gaps in treatment, dramatic claims that don't align with charts, or social media that contradicts your limitations undermine trust and reduce offers. Venue matters too. Some juries tend to be conservative, others more receptive. Defense tactics like sending you to a doctor for an independent medical exam or hiring experts to minimize your injuries are common. Preparation blunts the effect. Timing also matters. Settling before your treatment plan stabilizes risks, leaving future care off the table. Waiting too long risks bumping against the statute of limitations or losing leverage as records go stale. Litigation is a tool, not a threat. Filing suit unlocks discovery, subpoenas, depositions, and inspections that can strengthen liability and clarify damages when voluntary cooperation fails. Finally, facts can push value higher. Drunk or distracted driving, repeated safety violations in commercial cases, or conduct that borders on gross negligence. They change how a jury might react and how an insurer prices risk. Knowing the levers is useful. Putting them to work is where experienced help pays for itself. Insurance companies calculate numbers to protect their bottom line, not your recovery. That's why getting legal help early makes all the difference. We can help you document your damages, challenge low offers, and make sure every part of your loss is accounted for, not just what's easy to total on paper. If you or your loved one have been in an accident and you're feeling overwhelmed or unsure about what to do next, you don't have to figure it out alone. At Oberg Law Office, we've been helping injured Texans for over 30 years, and we're here for you too. Call us at 972-682-9700. Let's talk about what happened and what your options may be. And if this video helped you, don't forget to subscribe and check out the next one.